Hello. Hello.
Today's session, sir.
So I think it is also visible.
Yes, sir.
So shall I start?
Yes, sir.
Okay. Good afternoon to everybody. Today we are going to discuss one of the important topic and which is most disputed by the department. That is the taxability of the compensation received by an allottee of a building or a housing project where the compensation is awarded by the RERA or the consumer forum. So before going forward for the detailed discussion, I will take some time to brief about to the taxability under the Income Tax Act. The intent of this discussion is many newspapers or even also articles, even professional magazines or professional publications. You might have seen that many tax issues are coming up. Discussions has been made or article has been referred by our readers, but you will find very rare articles on the taxability of the compensation which is given as per the order of the RERA or the as per the order of the consumer forum, or the subsequently if the builders or the housing project owners going to the higher forum, maybe High Court or maybe Supreme Court, and in that case the award has been given and its taxability in the hands of the allottee under different circumstances where rare articles has been published. So this article actually today what the point we are going to discuss, it may not be entire compensation in different forms. Two forms of compensation which is received in the nature of compensation but calculated as an interest. So on that, I am going to focus for the discussion. This article, one of my article published, you might have seen. So let us, before discussion, I will highlight the provisions of Income Tax Act, which will help you to understand the judiciary decisions which I am referring here. Friends, you are aware that the Income Tax Act 1961 and subsequent Income Tax Rules 1962, which contains the provisions and the procedures that has been laid down, and subsequently the circular and notification has been issued with regards to the income tax related taxability, and then it contains the which receipts are to be treated as a taxable income and the assessee as a recipient will pay the tax. The income tax rules will not override the Income Tax Act. The circulars issued by the Central Board of Direct Taxes clarifying different points is binding to the department, not binding to the assessee. Notification is issued in a compliance to the law or in the, related to the law and which is binding to everybody. And my purpose of explaining these provisions, the main reason is while we are going for detailed discussion on different points of taxability as well as the judicial decisions, this will help to you. We know that the capital receipt is not taxable under Income Tax Act except capital gain. Revenue receipt is taxable. What is revenue receipt? Capital receipt is may not be the same as in the nature of our accounting. So usually what happens, whatever receipts has been one is receiving, the assessee is receiving, or different types of assessee they are receiving. It is to some extent there is a exemption provisions has been provided under section 10, mostly it contains. And while the other receipts, it is categorized under different heads of income or sources of income. The first source is your salary, which will not come in the today discussion while I am going to discuss about taxability or compensation. Business profession, house property income will also not come. But the most important discussion, which while we are referring, it may be concentrated on the taxability of compensation under capital gain or other sources or at all not taxable. The three possibilities, whatever compensation received or the interest received because of delay delivery, etc., it may not be taxable. If the dispute will arise, there is a possibility of a taxability under the capital gain. There is a lot of dispute that no, it is not capital gain. It should come under other sources. But if it will be computed under different heads, either under capital gain or under income from other sources, but it has a larger impact on taxation in the hands of the individual allottee or the person who received the amount from the builder under different circumstances. And in the process, I will discuss also if it is capital gain, how the capital gain will be computed and what is the judicial pronouncements are there. The whether it is a interest or it is not interest. If interest, why it is interest income? If not, then what is the reason or logic or what is the judicial pronouncements that held that these are not interest income? And similarly, if it is other sources, then why it is other sources? Because again, I am telling different judiciary forums, tribunals mostly I am talking, you will find one tribunal is holding as a capital, it should be treated as a capital gain. Other tribunal it is holding as income from other sources. Some cases also it is hold that at all not taxable. There is no clarity on that. But today, whatever I am going to make the presentation, that is my own view, and it is substantiated with a number of decisions of the high courts and supreme courts, and I have interpreted by taking that provisions and discussing you. And I'm not discussing all the modes of compensation. I'm discussing a few modes of compensation, and very clearly I will clarify to you. So let us first discuss. Friends, you know that there is a RERA Act is there, where the regulatory act which has been formed, and I'm just giving a briefing. You know that housing is a very important requirement for everybody. And in addition to that, in many cases we found the citizens of India, the individuals or HUF, they always may have the house, but they wanted to make some more houses, maybe for different purposes. And why either they are having their own land on which they are constructing, they are purchasing land, they are constructing, or most of the cases nowadays you will find the housing societies, the builders, they are having announcing different types of projects in which the project has been taken in different modes. There may be joint development projects where the landowner handing over the land to the housing project owner and then getting a share in the housing project. That we are not going to discuss here. The second case is where the housing project has been constructed by the project owner or we can say the builder. In that case, the individuals or HUF or the person, they are, I'm using the word which is used in the income tax, that is the person. So they are requesting the housing project owner or the builder for allotment of the house in exchange of consideration that has to be decided, mutually agreed. And at present, you know that to regulate the housing project, the RERA Act has been formulated, where the housing project owners, before going for construction of the house and then making the advertisement, inviting the persons to request for allotment, collecting the money against the allotment of the houses. So that all have to be registered. After registration, then you go for the construction. And there are having a set of provisions in addition to standard documents has been now formulated. The builder cannot do the documentation It is a uniform documentation all over India by the all state RERA authorities, so that it will protect the interest of the buyers. But in spite of that, it is found that when the individual or the person made an application to the builder and verified all the documents, the very important document is to find out whether the builder society or the project is registered with the RERA or not. From the website, one can verify it. They cannot go for more than the approved construction. Local authority which has approved with a different design, they cannot go beyond that, because there is a strict punishment in addition to penalty provisions are there, and there is the court order has been demolished. So now question is, when the applicant make an application, a house has been allotted, the construction may started, may not started. Allotment may be in the pre-construction, then construction starts, or in the middle of the construction, or even also end of the construction. And particularly in the middle of the construction or in the beginning of the construction, when the applicant make an application and make the payment, or used to make the payment in installments, but with a time frame, but the builder could not provide the house. So in that case, the allottee, we can say the person who has been assigned with a house to be constructed, is known as the allottee. The allottee, since he could not get the house within the stipulated period, or even many cases they could not get the house at all. Either the house has not been fully constructed or could not be completed, or because of certain dispute in the property, land and property, it could not be further progressed, and years together it could not be completed, and the builder, sorry, the allottee is going to suffer and request for making the payment with the compensation. So in all the circumstances, if the builder could not agree, even also not honoring to the builder buyer agreement, then in that case what happens? The buyer is going to the RERA, and also sometimes the buyer, instead of going to the RERA, they are also going to the consumer forums. So both have the power to give the compensation, and we can go on discussing that also. So in that case, that compensation or the interest or delay damage occurred to the allottee has been paid by the builder, either so much or as per the direction, the situation, whatever may be from the taxation point of view, it is the same. So in that case, how it will be taxable under here? So you might have seen the section 18 of the RERA Act. It provides that if a promoter fails to complete or is unable to give possession of the apartment duly completed by the date specified in the agreement, agreement means builder buyer agreement, the promoter would be liable on demand, mark the word, liable on demand, to return the amount received by him in respect of that apartment if the allottee would case also, if within interest in lieu of the delay in providing possession. Wherever the possession could not give in and the time period is over, the allottee may withdraw from the project and seek the refund of the amount along with the interest or along with the compensation. So there are different possibilities are there. Such right of an allottee is specifically made without prejudice to any other remedy available to him. In other words, I made an application in 2013 for one housing project. The housing project could not be completed up to 2019. That time it was not RERA. RERA has come subsequently. Since it was in progress in 2019, so accordingly, the project also treated as a RERA project. And accordingly, the houses has been completed, but it could not be handed over because of a non-completion certificate issued by the local authority, municipality or municipal corporation or the development authorities. And because of delay, the target period was 2013. Let you take. So beyond 2013 to 2019 or 20, when the house is handed over, so in that case, the allottee or the allottee can also seek the compensation, maybe in different forms. In the nature of interest, maybe some damage, maybe some other form, but of a monetary compensation which he received. So in that case, he has not withdrawn from the project. But many cases we found the person concerned has withdrawn from the project and seek for the is the refund of the amount deposited along with the compensation or in the interest. Many cases you might have seen existing house owners. Let you take a housing society where later 100 persons are having the house, and a builder has come told that these are old houses, so you hand over the building along with the house. I will demolish the house, I will have a flat here, I will allot you. So that is maybe also situation. So in that case, the compensation may be slightly different. It may so happens that the period for which the house is under construction, the person concerned will go for renting of the house, take the house on rent. The rent will be paid by the builder. In addition to that, the builder has to hand over the share of the house. And if it is not provided, now question is the time period of handing over or the completion of the project and giving possession has been over. So in that case also, the buyer is sought for the not only the house compensation, but also in addition to that rent which was paid as per the agreement, that rent, because where they will stay. So this type of also present there. Some other situations, just I'm telling, you will find sometimes so happens that the allottee made with allotment in a housing project. The housing project could not completed because of disputes with the landowner or with the different authorities. The housing project, the promoter sometimes also offers second house. Okay, this project could not be completed, so I am allotting you second house. And again, it may so happens that the allottee visited second house, may not accepted or accepted, found that second project could not be completed. So he wanted to withdraw also. So there may be different situations. So ultimately what happens, we can conclude that when the house could not be completed or the possession of the house could not be given within the time frame or within the scheduled date, so in that case, the allottee can seek refund, or allottee, even after the allotment of the house, possession of the houses, can seek the interest or compensation because of the delayed delivery. So delayed delivery or the seeking of uh, uh, the refund of the money along with the interest. So mostly my presentation, whatever I have given, this is a situation where the allottee has withdrawn from the project and sought the refund of the capital amount along with the interest and along with the compensation also. So how it will be taxed? So right, so given, actually the second sentence what I was discussing you, when the right of an allottee is specifically made without, specifically when he is withdrawing, so that does not mean that he will get only refund. He can have other rights also without prejudice to any other remedy available. So any other event is a different. For FERA is there, civil suits can be made. The consumer forum is also there. Parallelly, consumer forum, RERA both are working also. One can see which is more convenient, easily one can get it. So that is there. The right so given to the allottee is unqualified, mark the word, and if availed, the money deposited by the allottee has to be refunded with interest at such rate as may be prescribed. Generally, most of the RERA cases, it is prescribed that the compensation, whatever, or the refund of the capital amount which is deposited will be made along with the interest as applicable to the interest, at the rate prevails in case of State Bank of India. And the provision section 18(1) of the RERA contemplates a situation where the allottee does not intend to withdraw from the project also. Already I told you, you are not withdrawing, but you are claiming for the delay period compensation. You are withdrawing, you are seeking the refund along with the interest and the compensation. So he is entitled to and must be paid interest for every month of delay till the handing of the possession. It is up to the allottee to proceed under section 18, or you can proceed under Consumer Forum Act. And many cases, Consumer Protection Act, people preferred instead of going to RERA also. The RERA Act definitely provides a remedy to the allottee who wishes to withdraw from the project and claim the return of his money. So this is the regarding the provisions of the RERA in a brief, which is related to our subject. So that is also already I told you, Consumer Act is also there. So in that case, the Consumer Act was Section 14 of the Consumer Protection Act 1986 or the 2019. Certain amendments has been made in the 2019. So if the Commission is satisfied that any allegation contained in the complaint about the service are proved, it shall be issue an order to the opposite party, directing him to return the money to the complainant along with the interest and the penalty. So that is a always you see Consumer Protection Act looks about the deficiency in service. It is just like not only housing project but any other article also, goods also, services also. Consumer Protection Act is protecting the consumer against the deficiency of service provided. Deficiency has been defined in the section 2G of the Consumer Protection Act, which also includes the shortcomings or inadequacy in the performance which has been undertaken by a person in pursuance of a contract or otherwise related to any service. So there must be a contract or there must be a warranty. So accordingly, they could not perform. So there is a deficiency of service. For deficiency of service, one can go to the Consumer Forum. And it is clear from the statutory provisions that a commission is empowered to direct a refund of the price along with the interest or compensation. So now, both the situation, whether you go to the Consumer Forum or you go to the RERA, but generally when the when the person concerned deposits some money with the promoter, or we can say the builder, layman sense we can say the builder. So in that case, there is a builder buyer agreement has been executed. RERA Act contains the provisions, and for your kind information that the builder buyer agreement now become a very uniform clauses and applicable to all over India, and every RERA authority has enforcing it that the builder or the promoter has to cannot go beyond the clauses which has been in the model draft agreement. So there is a builder buyer agreement. When the builder buyer agreement is there, so definitely after that a flat has been allotted as per the builder buyer agreement. Builder buyer agreement mostly contains the details of cost of the house, how it will be paid, installment payments, obligation of the builder, obligation of the allottee, date of possession, which date the housing has to be handed over to the allottee. So these are the containments are there. So when the builder buyer agreement has been signed, so definitely a letter of allotment has been given. So that letter of allotment is one page of paper contains with the agreement as an annexure. So subsequently, a builder buyer on the basis of a allotment letter, so builder buyer agreement has been executed, which is referred to the housing number, flat number, or block number of the project. So now question is, a contract is a legal document, no doubt about it, and the buyer is known as this agreement in a very common parlance now it is known as a builder buyer agreement. It outlines the circumstances under which the builder will complete the structure and the price of the property, piece of the property for a consumer. And the purchase price, delivery date, terms of payment, different specifications, design, the permits, etc., which is required to be taken, the obligation of both the parties, everything has been contained. It is just like your normal agreement which is made, but it is very minutely one has to go for the seeing it. And what the importance of the builder buyer agreement in the home buyers agreement to ensure that a home building process is completed as per the buyer's expectation. House buyers should sign the builder buyer agreement. The contract describes the precise rights, duties, and demands of both the builder and the buyer. It aids in shielding the purchase from any controversies or misunderstanding that can develop through the development process. Additionally, it lays forth the precise terms and conditions that must be followed by the both the parties during the entire construction. The guarantees that the builder will be paid for their price and that the buyer will obtain the quality home that fits it. Again, I'm telling once the builder has handed over, but there is also warranty period within 5 years, I think, to my understanding. So whatever any deficiency, the builder has to fulfill that to restore it without any cost. The builder buyer agreement is a binding contract that needs to be brought viewed. So it is very important. Generally, one has to go through it and before signing it. So with this background, now question is, whenever the builder or the promoter fails to fulfill its obligations and could not deliver the flat, already I told you, could not deliver or give possession of the flat within the time period, then the allottee has all the rights to withdraw from the project and seek the refund of the amount along with the interest and compensation. So interest is one, compensation is one, and a refund of the getting back your deposit is one. So three types of amount is paid by the and generally this has been most of the cases mutually it is given, and in many cases it is not given mutually. So the allottee is going to the RERA, the going to consumer forum and waiting for a long period also. And nowadays the consumer forum is very speedy. RERA also accordingly they are acting. So either way the compensation is received and which is generally calculated at a percentage of applicable bank rate. And you might have seen those who are having some experience or knowledge, you might have seen ultimately all the orders passed by the RERA or the passed by the consumer forum. Subsequently, if you build a disputed by the High Court or the Supreme Court, you will find it is always calculated as a percentage of the total amount of the cost of the house, and according the for the period also. And so in view of above provisions, already what I discussed, there are a Consumer Protection Act. It is reported that many of the allottees of the flat have not been provided with the allotment to the house within the time frame. So thereby they are receiving the compensation. So this is the general provisions of the act. So on this background, just 1 minute. 8 ହୋଇଛି ଏଟା ହଁ ଚାରିଟା ତାରିଖ ଅଛି ମ୍ୟାଡମଙ୍କ ସାଇନ କରି ମତେ ଦେବେ ମୁଁ ତା ସହିତ କଥା ହେଇଛି ତ ଆକ୍ଚୁଆଲି ସିଏ କାଲି ଯୋଉ ଡେଟ୍ କରିଛନ୍ତି ଭୁଲ କରିଛନ୍ତି ତାଙ୍କୁ ଆମେ ଗୋଟେ ଲେଟର ଦବା ସେଟା ମ୍ୟାଡମ ସାଇନ କରିଦେବେ ହଁ ମୁଁ ସେଟା କରିକି ପଠେଇବି ଓକେ ମୁଁ ତ ୱେବିନାରରେ ଅଛି ହଁ 4ଟା ଆଜି ସାଇନ କରି ମତେ ଟିକେ ଦେଇଦବ ଆଜି ଦେଇଦବ ସରି ଆକ୍ଚୁଆଲି I have been disturbed for you for some time. Just see, so now with this background, now we have to let us also go for analyze whether receipt of a compensation, which is calculated as a percentage of bank rate of interest, as per the order of the consumer forum or RERA, is it taxable under the Income Tax Act? If so, under which source of income? So that is the let us first analyze. Friends, one point just I wanted to clarify you to whatever presentation today I am making. It is my own analysis, own view. One should not act. They can go for reference, examine themselves, take or seek the advice of the any legal advice. and accordingly acted. And I am not recommended to act what I am going to make the presentation. So that's why I am giving a disclaimer in the end of the my slide, so that anybody acting on the whatever we are going to discuss subsequently lose. So for that I am not responsible. So I am a legal person. So making a presentation taking into account all the provisions of Act, citing, and it is backed by any of the decisions what we are going to take a decision, but we should not act on upon that without examining it. So let us first understand whether it is a interest. Question, we know that interest on deposits uh, is taxable under the income from other sources. So now question is any compensation received. You see what happens. You deposited money, you got the entire refund. You sought the entire refund and told the builder that I will not wait for a long period, or I am not interested in the alternative project. Sometimes the builder also offered an alternative project. Okay, it is delaying, so don't take the return of your refund your money. The other you can go, I have another project, you can take it. But in that case, you may not also agree. So let us also see all the cases, whether you are shifting to not accepting the alternate offer, or you are withdrawing from the project, or you are getting the compensation in the which is calculated in the along with the interest. So in that case, even if also the you occupied the house, but subsequently but it is delayed, but after delay you are occupying the house. So for delay period one can get the compensation. I came across one of the project where the 2013 delivery was made in 2019, and the National Consumer Forum has given the order 9.5% interest of the delay period. So from April 2013 to September 2019, the amount whatever you deposited, accordingly, it has been calculated at the rate of 9.5%, and compensation has been paid, or we can say the interest has been paid. But that interest rate has been taken for calculation, but that is not actually interest. So how will you substantiate that is not an interest? Department is disputing that this is an interest. So before that, first we have to see that whether it is interest or not. Actually, interest is defined in the Income Tax Act, Section 228A. It is defined. You know that 194A, there is a section where it provides that the bank or any other person who accepts the deposits and pay the interest is required to deduct the tax at source. And I am highlighting many of that. That is one of the provision. And you might have seen in case of a business assessee, those who are not deducting tax at source, in that case under section 40I, 40AI and AIA. So that cases the expenditure will not be allowed as business expenditure. That is a restriction. So if a person, the amount paid, the payer could not deduct the tax at source on certain incomes, because started from 192, your salary 192, let interest other than interest on security 194, 194A interest on securities, sorry, interest other than interest on securities 194A, bank deposits, etc. 194 is related to interest on security. Similarly, 194 payment to contractor, like this. The number of provisions are there where the payer is required to deduct a tax at source. If you have not deducted tax at source, then it is not treated as your business expenditure. The restriction is limited to 30% of the expenditure it is allowed, and that is in case of resident payment. Non-resident case payment, 100% is it is allowed while computing the business income. That is a provision. So similar for the interest also there is a provision. So now question is, when 2080A subsection 20 subclause 2080A has under section 2, it is define the interest. So interest means just you can go through the wordings, that is very relevant. Interest means interest payable in any manner in respect of any monies borrowed or debt incurred. Mark the word. That means it will be treated as interest provided it is paid against money borrowed or the debt incurred including a deposit, claim or other similar right or obligation, and includes any service fee or other charge in respect of the money borrowed or the debt incurred, or in respect of any credit facility which has not been utilized. So in that case, question is there is a debtor-creditor relationship if there, whether that will be amounts to interest or not. Actually, what happens if you go to section 228A, a similar because that is also under the GST Act provision also there, because interest on deposits and advances also exempted. That is not liable to GST. So similarly here, interest, if it is not falling, any amount you received against the deposits, if it is not falling under 228, then it cannot be treated as interest. So for substantiate that, we can follow number of judicial decisions. So mostly today discussion, while we are discussing 50% related to the interpretation of judiciary pronouncements, 50% related to provisions. So that to substantiate our conclusion, that we have to go for the discussion. I'm just referring one of the decision, 2021 decision, just you see 2021 decision. In case of Sainath Rajkumar Sarode versus the state of Maharashtra, and it is reported in the Taxman. And interest by way of compensation falls outside the purview of section 194A and section 228A. 194A is deduction of tax at source from payment of interest other than interest on security. So other than interest security payments, deposit interest on deposits will be covered under 194A. Assessee entered into an agreement with a builder for purchase of 2 residential flats, and the flats booked were not delivered in committed period. Real Estate Regulatory Authority directly builder to refund the advance amount paid by assessee with a compensatory interest. Mark the word. Builder deducted TDS on account of a compensatory interest paid to the assessee. So it was noted that the amount payable to assessee was in the nature of a judgment debt akin to the judgment debt. Judgment debt means the debt which arises as per the judgments. So the party has gone to the different authorities. The authorities directed it to make the payments. So then it become a debt, and on which could not establish a debtor-creditor relationship. Here there is no debtor-creditor relationship, and nor was payment made by builder to assessee on a discharge of any pre-existing obligation. So there is no pre-existing. I deposited my money, builder refunded my money. So that's why it is not an interest. If it is not an interest, then it cannot be covered under the deduction of tax at source. Friends, I will go for 780 minimum judgments. There are more judgments also I highlighted. You can read it. But one thing keep in mind, still the dispute is not over. Okay, it may not be because TDS provisions is attracted, which are covered in the TDS provisions. But it may so happens that many incomes are taxable, but which are not covered under TDS. So that does not be, if it is not falling under 194A, as not interest, doesn't mean that is not taxable. That second part we will discuss subsequently. So first we have to see that whatever the different types of compensation received, whether it is interest or not. The reason is if it's not interest, then your major portion is gone. So that is the for discussion. The second one we can see the Calcutta High Court in case of Principal Commissioner of Income Tax versus West Bengal Housing Infrastructure Development. That is a very important judgment which is referred by many of the courts on this account. So what are the discussion has been made there? What is the decision has been given? Now the first is it appears that the term interest has been made entirely relatably to money borrowed or debt incurred or various gradations of right and obligation arising from either of the two. So in the case of housing project, there is no money borrowed or there is no debt incurred. So because as an allottee, I deposited the money. So there is no borrowing at all and no debtor also. And the compensation becomes evident from the word used in the clause. Actually, the interest clause, if you see, it is a quantification. Actually, if you go to the RERA order, or if you go to the consumer firm order, the interest rate has been taken only for quantification of compensation, but not treating as interest. And in many cases, you will find they also highlighted that it is for the only quantification. Okay. And why the Calcutta High Court judgment is very important, because it was department went to the Supreme Court, and Supreme Court upheld the decision of the High Court. And that's why it is referred by most of the case. And again, it is 219 year decision. So since there is neither any borrowing of money nor incurring the of debt part of the assessee in the present factual scenario, interest are defined in section 228 would not be invoked, or we can say it cannot be treated as interest. And there is no obligation on the part of the assessee to deduct tax at source. And again, I'm telling, this case arises because of the 40A IA. Already I told you, since the housing society is a business assessee, so definitely the department has disallowed the expenditure. So that time it was 100, and now it is, I think it is 2019, but the disallowance earlier was 100%. Subsequently, it was limited to the 30%, because to the tax person only. And taking the general rate of tax 30%, and provided they are the resident. And in view of above, we confirm the decision of the tribunal. So actually, the tribunal has given in the favor of the assessee. The department went to the High Court. Again, it has come to the assessee. Then the department went to the Supreme Court. And also again, it is in the favor of the assessee. The third is Beacon Projects, which is a 2015 decision. And in that case, the principle laid down. Actually, all the cases the same. The pre-existing debt, there must be obligation, etc. If that is not there, then we cannot say that this will be treated as interest on deposits. So in this particular situation, the obligation is the purchaser had paid a certain amount to the appellant. The latter point of time, the purchaser opted out of the agreement, and the appellant entered into a fresh agreement with new buyers for prices that are higher than what was agreed with the purchaser. Out of the receipts from new buyer, the amount has been paid along with the interest. So the principle is the same. So where all the cases, the interest also given, and accordingly it has to be treated as, or how it is be treated as not taxable. The amount thus refunded to the purchaser represent the consideration of the purchaser paid towards the undivided share in the property agreed to be purchased. You know, whenever you are going for purchasing any property in a housing society, it is undivided. You are having a flat, but in the land you have an undivided share. And the construction of the apartment which what was entrusted to the appellant, being the builder. That where the debtor-creditor relationship will be established, in that case, the or any obligation you have to discharge for the past obligations or pre-existing obligations, then in that case it will be treated as interest under section 228A. So, but in this case it could not exist, so we cannot say it is a interest. Similarly, HP Housing Board, many cases I have many number of cases I have given. You can go through it. So, so whatever compensation, again, I'm telling, it is also recorded in the particular case, Himachal Pradesh, HP Housing Board case also. Just to see the last portion, the red portion, it may be true that this agreed to find out a situation and a convenient system of calculating the damage. Actually, almost all agreements you will find only writing the interest is not solve the problem. The how it will be calculated, that will be taken into consideration. Similarly, other are there. There is a Bikram Singh versus land acquisition collector as the Supreme Court decision. A similar view they have taken. The amount was paid under the self-financing scheme for construction of the flat, and the interest was paid on account of a damage, damage suffered by the claimant for delay in completion of the flat. Actually, the purpose is when a flat has been allotted and it is delayed, so it is nothing but the alert suffers. So it is a mental agony. First is the money has been paid inconveniently. They had staying. They even if money paid, they could not get the house to stay because which is a basic requirement. So that's almost all cases court hold that. So these are the damage suffered is paid by the builders to the allottee. Kajabad Development Authority N.K. Gupta 2002, that is the similar issue also. Interest to complainant has not been awarded on the basis of any deposit made by the complainant or the GDA being a borrower of any money to the complainant. Here the interest payment is by way of damage. Merely describing the damage but by way of interest do not make them the interest under the Income Tax Act. So these are, you see how the court analyzed the decisions, different decisions, analyzed the fact and providing different decisions and concluded that so far whatever we discussed conclude that there is no debtor creditor relationship. When the amount is paid, there is no pre-existing obligation was there to make the payment. Third is it paid for the damage suffered by the allottee. Both it is calculated. The interest is only the medium of, or the quantification of the compensation. So in that case, we cannot say it is a interest. So these are the decisions are discussed, and here you see the wording. Before parting, we may make it clear that interest 12% per annum on the refund of the amount which has been awarded as a compensation and not factually as interest on refund. Therefore, there is no question of deducting tax at source. So my point here is what I discussed. I wanted to say that it cannot be treated as interest, because if it is interest, then the department will tell that it will be treated as income from other sources. But again, I'm telling, we are just the case laws, whatever giving some input, and mostly the discussions are related to the TDS deduction. But it may so happens that it can be income from other sources, miscellaneous receipts. Possibility is less, but it can be miscellaneous receipts. But it may not be interest income, but it may be receipts which can be taxable. Then the question will come whether revenue receipt or revenue receipt or it is a capital. Revenue receipt usually means there is a flow of money every year, we can say, or we have an asset and we are getting the income every year. That is revenues. That cannot be capital. The capital asset is employed to get the regular income. That may be revenue income. Capital receipt means occasionally, which never expected. All of a sudden you got it. You have one house. Not covered under the taxability under the calculating capital gain. So a capital receipt also, a portion of the capital receipt is taxable. Why I am talking portion? A little bit I will discuss here. My second point, which is concentrated on the capital gain, whether the amount of interest received by the allottee of a flat as per the order of RERA or the consumer forum is a capital receipt and is liable to capital gain. Already I told you, if it is a capital receipt, a portion will be treated as a capital gain. Section 45 contains that the capital assets, if transferred, then you will get the capital gain. And what is capital asset has been defined. There is some exclusions are there, stock in trade, urban land in rural area, some household articles, gold, jewelry, platinum. These are treated as household articles. Very few exclusion. All other assets are treated as a capital asset. Tangible or intangible, there is no requirement. The capital asset can be tangible. The capital asset can be intangible. And again, I'm telling there is a transfer. So transfer has been defined. Actually, there is a provision under capital gain, and there must be a capital asset. There must be a transfer, and a transfer must have been made in lieu of consideration. And the consideration will be taken from where the cost of acquisition and index cost of acquisition will be deducted. So capital gain when computed, so there is a transfer of a capital. So transfer may be different form. One is sale, barter, exchange, relinquishment. Generally, relinquishment is intangible. You have a right which you are relinquishing. So relinquishment of right or the extinguishment of right. You have right, you relinquish the right. Actually, which is very important to the present discussion. So when a capital asset is transferred for a consideration, then the question of a capital gain will come. And if your capital asset already I told you, there is no actually in the accounting we call the capital asset. There are two things, but under the income tax there is a definition of capital asset. So there is exclusions are there. In that exclusion, stock in trade, it is not a capital asset. Your gold, jewelry, bullion is not a capital asset. Your personal effects is not a capital asset. Your land in the rural area is not treated as a capital asset. So mostly, and gold bond and some specified bond. So these are not treated as a capital. All other in the world, whatever remains, all are capital assets. And when there is a transfer of capital assets, then the capital gain will come. And if the capital gain will come, then it will be computed. And it has been divided in two parts. So one is the short-term capital gain, one is the long-term capital gain. In case of share and securities, if the holding period is 12 months, then we can see it is a short-term capital gain. But in all other cases, if the holding period is more than 12 months, 36 months, then we can see it a long-term capital gain. So in long-term capital gain, there is a flat rate of taxation. And in case of short-term capital gain, it will be treated as a normal taxation. You will add it to your taxation. There is no special rate. So this much you remember. And when I'm going for the calculation of long-term capital gain, indexation benefit I have to give. Consideration, less cost of acquisition, less expenses. That will be net is your capital gain. That is short-term capital gain. But in long-term capital gain, you have to take a consideration, less index cost of acquisition, less expenses, less index cost of improvement, the difference is your capital gain. And you might have seen Finance Act 2022 made some amendments. In that case, no indection is permissible after 2023. So in that case, a flat rate of taxation is applied. So you can go through in detail. So my point here is whatever compensation received, we treat it as a capital gain for the purpose of computation of our taxation. Here, the compensation which we received. Let us also first discuss that. So now agreement, first is the in the buyer by builders agreement, how the capital, which one is the capital asset? Because I am the builder, you are the allottee. You approached me, I have given an allotment letter. When I'm giving an allotment letter, what I have given, let I'm constructing 10 towers. In each tower, I have 100 houses. Let accordingly. So 4 towers means 400 houses. You requested for one house. I issued an allotment letter. And allotment letter means it is specified. Let the block A, flat number 705. So 705 is the house number, and block A, already I told 4 towers. So A, B, C, D. So A tower. So that is that the allotment letter always specify which flat it has been allotted to you. But flat either has not constructed, or under construction, or not completed. But it is given because the approval of the local authorities or the development authority already given. for construction. So on that basis, you have been followed with a allotment letter. So while you are going for the allotment letter, then you are executing a buyer builder agreement. When you are executing a buyer builder agreement, then you are starting the making the payments. Even also part allotment time also you are making payment, some payments before also buyer builder agreement. So as per the buyer builder agreement, you go on making the payment. So till that date, till the possession, the house belongs to the builder. Only you have been identified with the allotment letter. So now question is, if the money refunded to me, how it will be treated as a capital asset? So that is the question I wanted to also explain to you. So in my context of discussion that when one allotment letter has been given, a right has been created. Already I told you in the capital asset, it may be tangible, it may be intangible. A right to right is also one capital asset. How you got the right in the allotment of the flat? So whatever the decisions I have for the discussion before you, and substantiate that it can be treated as a capital gain of the transfer of on the relinquishment of the house or getting a compensation. Getting a compensation is second part of this. Relinquishment of a house and get the money. So how it will be treated as a computation of a capital gain. So allotment is identified the flat. When allotment letter is given, it is identified flat. A letter of allotment is given. Buyer's agreement is. So you have the first is you have one document that is allotment letter, which very clearly shows that let a flat number tower number A and a flat number 6705. So the identified. Second is buyer builder agreement is executed. So that is your. So now with the relinquishment of such right, when I decided not to take the house because the builder could not provide me in time, I relinquished the house. Relinquish means my right to tower A, flat number 705 has been withdrawn. So I told, okay, you take back your allotment letter, cancel your buyer agreement, pay me the compensation. If they have not paid, then I'm going to the order that you make the payment. So once they made the payment, my right is not there. Subsequently, I cannot say that, okay, you give me now the flat number 6705 and tower A. You cannot tell that. So till the relinquishment, you have the right. So whether that relinquishment will be treated as a transfer or not. Section 214 defines capital asset, means any property of any kind held by an assessee, whether or not connected with the business or profession. There is no requirement of business profession except the exclusions. And the property has been includes and shall be deemed to include any right in or in relation to an Indian company, including right of management, control, or any other right. So you will see the explanation is there. So you have a right, you can enforce it. So that is the very important. Section 247 of Income Tax Act provides transfer in relation to capital asset, the sale, exchange, relinquishment of the asset, and extinguishment of any right. Extinguishment, relinquishment, with there is a difference. I am giving an example. The relinquishment meaning is I have a right on the tower A flat 705. Now I told my builder, no, I'm not interested in the getting back or taking possession. Only when you complete it, refund my money, and I am relinquish this. So the moment he refunded the money, I don't have any right on that. I relinquished my right, given up my right. And extinguishment of right meaning is actually there's no two party. Unilaterally, you have taken out your right. Let three brothers are there. Father died. Three brothers are there. So they have equal right. One third, one third, one third. The elder brother has extinguished this right. Means father died. It has been divided three parts. He has not taken anything. So when he has not taken anything, the other two brothers got half and half, 50-50%, instead of 33.5%. 33.33%, 33%, because of divided by 3. Now it is divided by 2. So the right of a 33.33% of the right of a elder brother is he himself extinguished his right. So both the cases, right is also treated as a capital asset. So if we above definition we will see, then if I am relinquishing the right, so when I am myself surrendering the right, we can say, and getting back my compensation, either so much the builder is giving to you along with the interest and other cost, or the as per the RERA it is given. So both the cases you are relinquishing the right. So now question is, if that is a capital asset, can it be treated as a capital gain or capital loss for the purpose of computation? Yes, because a number of decisions are there where it has been decided that it will be capital gain and accordingly it is taxable, and it should not be treated as income from other sources taxable. And if it's a capital gain, then the question will become long-term capital gain, short-term capital gain, tax at a lower rate than normal rate. So these things will come. Let us also see. The property is a term widest import, signifying every possible interest which a person can rely to hold or enjoy. It has been held by the Honorable Apex Court in Ahmad GM Arif. So this is a old tax case. So that means it is the term is very widest import. So if you have interest which a person can clearly hold or enjoy. So because once a allotment letter has been given, no more other can going to take it. The builder cannot give it to anybody. I have that till the date I can sell or till the date I would run. If a second person will take it, he has no right. Knowingly or unknowingly, many cases you might have seen the builder also again selling alerting to somebody, double alerting. But in that case, the second one may not get the right that what the first one is getting. So now I have gone through many of the decisions. So I have gone to section 47 V and VI, we can say small VVI, and explanation 2 makes it clear that the possession, enjoyment of immovable property as well as interest in any asset are the transferable capital assets. So that now there is no doubt about that it is intangible. So there is a transfer, it can be capital asset. The transfer includes and shall be deemed to have always included disposing of or parting with an asset or any interest therein, or any interest. I don't have an asset, the allotment letter, I don't have an asset, but I have an interest in the asset. So I am parting with the interest of an asset. Creating any interest in any asset in any manner whatsoever, directly or indirectly, absolutely or conditionally, voluntarily, involuntarily, by way of agreement or otherwise. So all are treated once I parting it will be treated as transfer. Right or interest in a property are kinds of property that are transferable as a capital asset. So booking right, mark the word. Allotment letter is against the booking right, right to purchase the apartment, right to obtain title to the apartment are also capital assets. So by definition, we can conclude that it is capital asset. But again, it is not sufficient for me. Then I have to go by the judiciary decisions for the purpose. So I am going first with the one of the circular number 471 dated 15th October 1986 that has been issued by the CBDT, and the related to the it is clarified that holding it is clarification was an assessee purchases a flat to be constructed by the Delhi Development Authority for which allotment letter is issued. The date of issue of allotment letter would be relevant date for the purpose of a capital gain tax as the date of acquisition. And again, I am talking. I have seen few circulars where it has been clarified the central government that if because there is a housing loan facilities there in the central government, state government, as well as a public sector undertaking, banks, etc. So it is also clarified that once the allotment letter has been given by the Delhi Development Authority, then you can also avail the loan or advances as a housing building loan. So that means it proves that the purchases of house by allotment letter, that means you have a right. It is noted that allotment is final unless it is cancelled or the allotment is withdrawn under the scheme, and would cancel only under exceptional circumstances. Till it is not cancelled, then you have a right on that. The allottee gets a title to the property on the issue of allotment letter, and the payment of installment was only a follow-up action by taking the delivery or possession of the house. So, in other words, the property on the issue of allotment letter. So, allottee gets a house on the issue of the allotment letter. Other the paraphernalia, whatever is there, that is related to the payment of installment till the completion and getting back. So by going through the CBDT circular, this is also the below one what I was telling. The board has considered the matter and has decided that if the terms of the scheme of allotment and construction of flat house by the cooperative societies, other institutions are similar to those mentioned in the para 2 of the board circular 471 dated 15th October 1986, such cases may also be treated as cases of construction purpose for section 54-55. Section 54 and section 54A contains that when you have a capital gain, then the capital gain tax will arise. But if you invest the capital gain in the purchase of another house, both cases the house purchase is there, section 54 and 54A. Difference is section 54, you transfer the house property and then you acquire the house property. You transfer the house property, purchase or acquire another house property, then you will get deduction under section 54. The difference amount only taxable. Under section 54 investment, you have any house, any capital asset transfer has a capital gain, but you are acquiring the or taking possession or purchasing or constructing a house. So in second case, transfer asset is any capital asset, but the new asset is a house property. In the first 54 case, the transfer is house property, the new asset also house property. So it has been clarified that if any allotment letter has been given and according installment paid, whatever installment paid is nothing but an investment in the house property. Accordingly, you can get the tax benefit of 50 and 54. So it is from here, it is substantiate that right is nothing but this is one of the first argument. We can go for many arguments also. And ultimately, it is based upon the decision of different high courts. I am taking first the Supreme Court judgment in case of Bania Silk Mill, where it has been actually this after this judgment given, the amendment has been made, act has been amended. But still then, the basic principle based upon which it was made, it was not amended, which is related to the present context of discussion. I am talking about this particularly talks about 247, section 2, subsection 47, and section 45. And it is absolutely clear that profits or gains which are amenable to section 45 arise from the transfer of a capital asset which is effected in the previous year. Why actually in this case, just I wanted to tell you the transfer may be brought about to any of the modes of transfer which includes sale, exchange, relinquishment of asset or the extinguishment of the right therein or compulsory acquisition of the asset under the law. It may be also another point is asset itself or any right in it. It may further be the result of a voluntary act or a compulsory operation. So whatever the mode by which it is brought about, the existence of the asset during the possession of transfer is a precondition. So now question is whether my allotment letter given by the builder and subsequently builder by the agreement is signed, that means the asset is in pre-existence. Subsequently, it will be constructed and then it will be handed over to me. Honorable Income Tax Appellate Tribunal, particularly in case of Deputy Commissioner of Income Tax, and where it has been held that the matter and considering the fact and circumstances of the case, following ratio laid down by the Honorable High Court, we are of the considered view that what was received by the assessee by virtue of a MOU, memorandum of understanding, is a consideration received for the transfer of a right in property, thus same is accessible to income from capital gain, right in property. And a builder buyer agreement is nothing but memorandum of understanding, we can say. It says that if the buyer, the seller could not hand over, then seller has to make a compensation, either in the lieu of interest or damage, whatever is mentioned, that is there. So that's why the court held very clearly that it is nothing but it is a capital gain. Then I am coming to the here the observation was the relevant fact, rightly the Commissioner of Appeal hold it as income from capital gain, but Department of the view that it is income from other sources. So that's why the findings of the learned Commissioner Income Tax Appeal and dismiss the appeal filed by the Revenue. So actually, while they are deciding, they also refer to the Madras High Court decision and Bombay High Court decision. Actually, Madras High Court decision, Bombay High Court decision was very clear about the relinquishment of right. So relinquishment of right is treated also as an asset. And on the Bombay High Court decision, if you go, just you see property used in section 2, subsection 15 was 14 was a word of widest ambit, and definition of this was re-emphasized by the use of the word of any kind. So property of any kind. So thus any right which would be called property would be included in the capital asset. So capital asset, what we discussed, fulfilling all the conditions. If we go to the High Court of Madras, again, you will also find, after considering the relevant facts, held that when the assessee had a right to insist on specific performance and such right has been given up readily and received a sum in question, sum means amount. So the same would be come within the definition of a capital asset, and consequently consideration is accessible to the capital gain. So that means from here, similar many other branches also there, allotment of land to the assessee by the builder, subsequently cancellation of allotment after considering relevant facts, held that compensation received by the assessee in lieu of a surrender of the right is nothing but a capital gain. Similarly, extinguishment of any right therein, including extinguishment of right in capital asset, independent or otherwise, then on account of transfer. So that is also Kerala High Court opinion that is also subject to the capital gain. So friends, more decisions also still there. Another decision just I'm telling, Abha Bansal. Actually, this is a very important case. Abha Bansal case, what happens? The Commission of Appeal has treated the surrender of the house as per the builder buyer's agreement is treated as a capital gain. The assessee treated it as a capital gain and also paid the taxes and filed the return, shown it. The advantages of taking the capital asset, capital gain is indexation benefit you can get, or the tax rate as per new provision is less. So they have taken it, but the Commissioner of Appeal gone for the revision. So then he has invoked section 263 of the Income Tax Act, directed for further assessment. Then accordingly it has gone to the tribunal. Tribunal hold that no, it is nothing but a capital gain. So this Abha Bansal case, after that I am giving Shiv Kumar Jatin another case that is also similar. The period of here another new things also come. So far, whatever discussion we made, almost all discussion it has been hold that is a capital gain. So it is relinquishment of right or the extinguishment of right. First is allotment letter is nothing but a right on a flat, unless it is cancelled. The right is still in existence. Surrender or in lieu of that any amount received, refund of the amount of deposit is nothing but a refund of your own money. Then whatever amount you received more, then it is also treated as your consideration, and accordingly you compute the capital gain. And while you are computing the capital gain, already I told you how to compute it. Now, the period wise, you have to the holding period is very important, and it has been clarified. The period of holding is to be reckoned from the date of first agreement while calculating the capital gain on sale of such property. So that means I have I made an agreement in the 2013. Moment on making the payment of installments, 2013 at the time of booking of flat, then agreement of the flat, then first subsequent first installment, second installment, third installment, that every 6 months, 6 installment paid. That 2017 was my delivery or the possession date. It could not be given. Now today it is given, or today I surrendered and get back the money. So now I have to reckon the period of holding from the beginning. Means when the allotment letter is given, builder by agreement signed it, then the right created. So from the date of right created, the holding period. If the holding period is more than 3 years, then we can say it is a long-term capital asset. Then the question will come how to compute it. Now your computation of capital gain will be based upon the installments. So that means the period of transfer will be treated as 2000 late 2024-25, and a period of holding starts from the 2017. Perhaps I told 2017. So 2017 index will be taken, and 2024-25, but 2024-25 index is not there because the finance year 2023 has a mandatory 12.5%. So 12.5% is the taxation. So whatever method is there, but it will be treated as long-term capital gain by counting it. So from the counting from the date of agreement, that means the right is created. So later it is more than 3 years. So now capital gain will be computed as long-term capital gain. There may be possibility of long-term capital loss also. So cost of acquisition and cost of acquisition, first is it should be a capital gain, then the taxability will come. Now it is indexation is not there. Actually, there is a loss to anyhow. This is one of the one article I have given in the tax research department. You might can refer in the month of after the budget also. Okay, so the new taxation is beneficial if the cost of acquisition, date of acquisition and date of transfer is within 8, if the consideration is 8 times of the cost of acquisition, then more than 8 times, then the new method is beneficial. Again, just I'm detail clarifying, it will much better. Just I'm telling, as per the old provision, now let us conclude the period of holding is to be recorded from the date of first agreement for the purpose of calculating the gain on such property. So if in 2017 the agreement has been signed and the house could not be delivered, let in this example you take the example 2017 the agreement has been signed, the house could not be delivered in 2019. Now it is 2023, 24, 25 will come subsequently, 23, 24. Then what will happen? Indexation is not there. And as per the old provision, indexation is there. Had it been indexation, how it will be done? Now the year of transfer is the consideration. That is the index. I think later 400 is the index. Year of acquisition means the date on which you signed the agreement. Let it is 250. So whatever amount you paid, it will be computed. The amount paid, that is the cost of acquisition, divided by the year of payment index, let 300. Now it is the year of transfer, let 400. So let 10 lakhs has been paid. 10 lakhs divided by 300 into 400 is equal to cost of acquisition. So every installment has to be computed like this. So that entire amount of installment indexed is total index cost of acquisition, then the consideration minus index cost of acquisition, then the difference is your long-term capital gain, and which will be taxed at 20% as per the old provision, particularly in case of building. As per new provision, very simple. Consideration is let 15 lakhs. Cost of acquisition is 10 lakhs. Difference is 5 lakhs, 12.5%. So now question here is which is more beneficial? Now more beneficial will be I was calculating that if the consideration received is 8 times more, up to 8 times, the old scheme is the old scheme is loss, new scheme is gainer. So if it is more than 8 times, then the tax payment is more than the old scheme. So if the consideration you are receiving 8 times of the cost of acquisition, or the investor cost is not there, cost of improvement, in that case, it is a loss to you because the tax rate 12.5%, even if indexation benefit is not there, then you are going to pay more tax. So whatever maybe, let us conclude it. If it is a capital gain, tax rate is less. So I have to pay capital gain at a lower tax rate. So that has to be seen. So right arose when assessee entered into an agreement. So that was the discussion, that was the output of this decision. Binod Kumar Jain case, what is the discussion is there? The same capital gain arising on sale of a shared flat was a long-term capital gain, and consequently, assessee was also entitled to set up same under section 54. Actually, if there is a long-term capital gain, you can also take the benefit of section 54 or section 54A. Short-term capital gain, section 54A benefit is not available. So these are the very important points. A contract for sale of a flat was capable of a specific performance, and therefore right is an uncompleted building or flat was clearly a property. So even if not completed, but you have a right, so this is an asset. So there are many decisions are there. So on basis of this decision, we can conclude that what is our conclusion? Our conclusion is an interest in any asset which is transferable as a capital asset. Transfer includes and shall be deemed to have always include disposing of or parting of an asset or any interest thereon in creating any interest in any asset in manner whatever, directly or indirectly, absolutely or conditionally, unconditionally, voluntarily or involuntarily, by way of agreement or otherwise. Right or interest in a property or kind of property that are transferable capital asset. So it is a transferable. Booking right or right to purchase an apartment, right to obtain title of apartment is a capital asset that can be transferable. So when it is transferable, but it is clearly satisfying the condition, sorry, the definition section 214. And a transfer may be brought about any mode of transfer. It includes sale, it includes exchange, it includes relinquishment, and the asset or the extinguishment of any right therein, or the compulsory acquisition of an asset. So whatever amount you got, that is your consideration. The asset itself or any right in it is it transferred. So this is result in consideration received which is subject to the capital gain. So friends, so far whatever we discussed, my view was interest is in nature of compensation, but it is not an interest. And many cases you will find the in addition to interest, that is also separated damage is also given. Damage in the nature of compensation also given. That is at all not taxable because that has been given because you suffered. So this capital gain, what I discussed, even if it is substantiated with many case laws, I come across with many of the decisions where it is also substantiated. One of the Bombay High Court decision recently, I was going through, recently means 1 year, around 1 year, I was going through, where it has been hold that the amount deposited for getting a building is nothing but a deposit, and they are substantiated with a few case laws also, and they are of the view that it is nothing but an interest. And if it is interest, it is income from, sorry, they are not substantially interest, they are substantially income from other sources. If it is income from other sources, then it will be computed along with your normal income, and which is taxable at the same rate as a normal income. So that there are few cases also there. So in this view, according to me, more weight that it is a capital gain, and as an assessee, you should not suppress it, disclose it as a capital asset, unless it is categorically given that this is a damage given because of the you suffered, loss suffered, or in lieu of damage it is given. Then you can think of that it may not be taxable, but always you show as a capital gain, take it and pay the taxes, nominal tax, or other sources. Many cases people also trying to not to go for dispute, pay so as other sources pay the taxes. So you decide accordingly, but still it is a very debatable situation, particularly in the present context. It is not clear. Government should come out with a clear provision in the Income Tax Act, whether it is taxable or not taxable. And my view is it should not be taxable. No such provision. The provision should come with a clarity and showing that the amount which is received is a compensation because the damage or loss suffered by the assessee. Loss damage suffered cannot be treated as income under the provisions of Income Tax Act. So there is no such income is there. It should be exempted or it should not be taxable. But that is the expectation from everybody's side. So with this, I conclude. If friends, you have any doubt, you can ask also. We can discuss. I am very much thankful to 135 allottees. Let us also see any question or answer question has been raised by any of our friends. I think it is not coming. Just wait. Wait, any questions? Just I will check. So it. Friends, if you have any question, you can also ask me.
Sir, there are no questions in the chat section.
Just I was going through anything is there. This is a very controversial subject, but I tried to put you my views based upon certain judicial decisions, relevance to the provisions of law. And if still you have any question, you can also ask. Let us also interact with each other. Will you close it? If
Okay,
no question is there. Thank you very much, sir.
Thank you for your time, sir. Thank you so much. We are ending the
Priyanka.
session now.
Okay, thank you.